Okay, hello everyone. Welcome to Law 2021 Online's Wills and Probate Shape the Debate. In this live session, you can put your questions to Lesley and James and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the Solicitors Group for further information. A recording of today's live session will be sent out by email within the next few days, so please keep an eye out for this. So moving on to our speakers for today. First of all, we have Professor Lesley King. Lesley King is a leading professional author and lecturer in wills, trusts and probate. Lesley is a former member of the Law Society's Wills and Equity Committee and the Probate and Estates Committee of STEP, and an honorary member of the Association of Contentious Trust and Probate Specialists. She's also a professional development consultant at the University of Law and lectures extensively on private client matters. As part of Law 2021 Online, Lesley's sessions include varying the disposition of estates and the impact of lifetime estates on estates administration. Secondly, we have James Beresford. James is a lecturer specialising in wills drafting and estates administration matters, and also helps his clients deal with their legacy planning, providing a comprehensive and understandable solution. He's a wealth preservation specialist focusing on inheritance tax for high-profile individuals and advising business owners on succession planning. He has been presented with 2 Private Client Team of the Year trophies at the prestigious Manchester Legal Awards, and is the author of No Will, No Say, a simple guide to wills and estate planning, published in 2017. Sessions today for Law Online are practical and profitable probate and the importance of estates accounts. So to kick off, we'll be starting with some of the pre-submitted questions we're receiving from you. The first one is a bit of a long question, so just bear with me. I think this one's going to Lesley, actually. So we have prepared a will for the client. The testator has just passed away, and we discovered that there is a clerical error in one of the clauses in the will. In the will, it states, if my husband survives me by 30 days, I give the whole of my estate to him. The reference of husband was made rather than wife in this clause. The will appoints the wife as the executor, and the estate will pass to her upon the death of the husband. Is the will still valid? Do we need to, or can we amend the reference of husband to wife? And if we can or need to, how do we do this?
Okay, thank you, Amanda. Well, in the old days, my advice would have been apply to Winchester Probate Registry with an affidavit explaining what's happened, and you had a pretty high chance that it would have got through. I think your chances of getting it through the online system with an explanation of what happened, pretty remote. I mean, you could try, but I don't think they're going to wear it. You are entitled to make an application for rectification on the basis of a clerical error. And I think that's probably your best shot. It's not a hugely expensive application. And as I said, I think there's little doubt that you would get an order for rectification of the will. So relatively short answer to fairly long question.
No, that's great, thank you. And we're staying with you for this one, Lesley. If someone varies to give up an entitlement, does it always affect means tested benefits?
Oh, I think I talked about this a bit in the recorded session that I did. A variation is read back and is treated as the deceased's disposition for the purposes of income tax and capital gains tax, but only for those 2 taxes. So for other purposes, the person who's left the legacy is making a lifetime gift. So, for example, if they went into care and the local authority was assessing their ability to pay, there would be questions about lifetime gifts, and usually they would also ask, has there been a variation of a will to give up an entitlement? So it is a lifetime gift. Now, quite recently, and I think I did talk about this in the recorded session, but quite recently we actually had a case on means tested benefits. And it's a useful case to look at. It's got initials in the title because it involved the Court of Protection, but it's something like FSS. But in this case, they talked about what affects your mean tested benefits. And if you have done something and the reason that you have done it is substantially to secure your means tested benefits, then the thing that you've given up will continue to be treated as part of your available capital. So the answer to the question, does a post-death variation always and necessarily affect your means tested benefits, is probably that 99% of the time it's going to, because why exactly did you give up this legacy if it wasn't to protect your means tested benefits? But on the other hand, if, for example, you felt there was some moral obligation, that there'd been a mistake and somebody else was better entitled to it, you might find that your explanation was accepted. But my guess is most of the time, if you give up a legacy, that is going to be treated as deliberate deprivation of capital and will affect your means tested benefits.
That's great. Thank you, Lesley. So coming over to James now. In your talk, that you say that you believe estate accounts are important. Why?
I think for me, they're really important and possibly one of the most important elements for the clients, because it's the first tangible product of an estate that they will be seeing. So they come in to see you, say, a year, 18 months before, and you take all the information off them, and then every so often, say for example, the executors will be getting forms from you, sign this, sign that, sign that. We're cashing in the estate, but when they see the estate accounts, they're actually holding the story of the estate from the date of death to the date of distribution in the hands. So it's really important for them to see it. They know what they're getting. For beneficiaries, obviously, they'll turn to the distribution account straight away to see what they will be getting, or maybe I'm being a bit too cynical nowadays. But it shows people what's happened through the timeline of the estate, and the clearer that we can make estate accounts, the better. I remember doing a talk down in Cardiff once, and someone, a lawyer there, said, "Oh, I make my estate accounts as complex as I can, so they don't understand them, because then they won't raise any questions." And I respectfully disagree with that suggestion, because actually I think we'll be doing a disservice if we don't make them as clear as possible so people can understand them. But yeah, I think because it's the first tangible thing that the executors and beneficiaries see, that makes them the most important part of the estate administration process.
I'd also throw in that I'd be particularly careful with your estate accounts, and this will come as no surprise to anybody, if you've got a charity as your residuary beneficiary, because most legacy officers these days do a course organised by the Institute of Legacy Management, and they're actually trained on, when you get the estate accounts, go through and here's a list of the sort of things that you ought to be looking for, and if you find these things, it suggests that something has gone wrong and you should be asking questions. So things like, if there's been a payment of capital gains tax, which could probably have been avoided had the asset been appropriated to the charity before sale. If there's been an appropriation to a pecuniary legatee, at what figure did you do your appropriation? Is that clear from the accounts? If it's not, the legacy officer will almost certainly come back and ask, at what figure did you appropriate? So I just say be really careful with them.
That's great, thank you. So we're staying with you, James, again for this next one. When should we start preparing estate accounts?
There's no easy answer. It depends. Some firms like leaving it right to the end as a kind of this is, we've done everything, we've got the work. I'm a great believer in starting it earlier on, because when you start dealing with the estate, it's a process. You are starting off a process. So I use Excel to start building up the picture of the estate as you're going along. So that's starting off by simply putting, say, down the simple estate, valuation of the house and the accounts, bank accounts, put down the account numbers. You can then build on from them with the date of death balances, the interest accrued but not credited, etc. And then as things happen, you can then simply add on to these accounts to build up the picture. If you leave it too long, there may be a chance that there may be the second fee earner who's now looking at it and can't quite remember, what happened and why this figure's come in. Whereas if you keep it always updated, you've got the figures to hand, you know why something's happening. And it, especially for some larger estates, it can be quite hard of going, there was an extra payment here. Why have we received that? And then you're digging through the file. Where actually, if you start at an early stage and just keep it updated, then you've got the figures to hand and it's easier. And it also keeps costs down for the clients. I remember a few years ago, I was dealing with the estate. It had been going on for a long time. And we actually employed a lady whose sole job was to do estate accounts. And I think her time charge for the estate accounts came to £9,000 because she kept on having to pick up the file, look at the, review the file, record the time spent in that, and then distributing it. And this estate had been going on for a good 10, 15 years. And we couldn't pass that charge on to the client. By the way, the cost for the legal fees was £10,000, but here's £6,000 worth of estate accounts. You say that with a smile. They just wouldn't pay it. So I think if you start off early, it reduces the chance of any mistakes and benefits the estate because it does keep the cost down going forward for the clients.
James, do you reckon on ever sending out interim accounts?
It depends on the complexity of the estate. If it's a relatively straightforward estate, then no, because I don't think clients appreciate. It's like, this is what you could have got. It'd be like bullseye. This
could be shooting yourself in the foot. Yeah.
This is where we could be. So I think for relatively straightforward estates, and I'd say anything below the nil rate band, I wouldn't bother. However, if it looks like we're going to be in the long haul for an estate where we're going to be going over a year, 2 years, I would do interim estate accounts then, really as a, this is where we're up to, but this is what we've got to do. I think, it's slightly away from the question, but more on the process for estate administration. I think what's more important at that stage is keeping the executors and the beneficiaries up to date, because that's the biggest complaint I've always seen. We don't know what's going on. What's going on? So I think interim accounts are great in the right circumstances.
Great, thank you. So coming over to Lesley next. Can you never use a variation to alter a discretionary trust?
You may be able to use a variation to alter a discretionary trust. It depends on who your beneficiaries are. The problem with a trust is that beneficiaries have no right to deal with the property other than through the rule in Saunders and Vautier. And under the rule in Saunders and Vautier, if you've got beneficiaries who are of full age and capacity, and between them they are entitled to the whole beneficial interest, so there is nobody else who can possibly be involved, then they can, wind up the trust, redraw the trust, do what they like. But it's very rare to have that with a discretionary trust. I have come across cases where you had a discretionary trust for the benefit of mum and the 2 adult children, and they were the only beneficiaries named. But it's much more common to have mum, the adult children, and any grandchildren, and potentially spouses and civil partners of those grandchildren. And sometimes people have said to me, oh yeah, but we're all right because there aren't any grandchildren at the moment. But the thing is, that class is open. And so there could be grandchildren and they could be added to that class. So you haven't got a Saunders and Vautier situation. So 9 times out of 10, you can't use a simple variation to alter or get rid of a discretionary trust. But it's not at all a problem, because by definition, the trustees have powers to appoint capital and or income from the trust. And so what the trustees will do is they will use those powers often to get rid of the trust by appointing everything to mum. And that will be automatically read back to the date of death under section 144. So you achieve exactly the result that you want, which is reading back to the date of death, getting rid of your trust or altering your trust, but you do it by a different method. You do it by a trustee's appointment, automatically read back under 144. And actually, I find people are often a bit unwilling to do a section 144 appointment. They almost want me to say, yes, you can do a post-death variation. But actually, a trustee's appointment is generally much more easy to arrange administratively, because if you do a variation, you've got to have all your potential beneficiaries agreeing and joining in, whereas with a trustee appointment, you've probably only got 2 trustees, and they're the 2 who will be signing the appointment. So not always, but not often is the answer.
Thank you. So next one for James. In your opinion, what would be a quick win to make my firm's probate practice more profitable?
A quick win. I think a quick win for you would, if you don't already do it, start scanning your wills on from today. The reason being is if you scan your wills onto your system after they've been signed, when the time comes, as it comes to us all, if you look at it from the family's point of view, they're phoning the solicitors, they may not have had any involvement with you, and we all know people have a distrust of solicitors, or they don't like phoning it. We're akin to dentists, and they'll phone up, they're obviously nervous, they don't really know what's going to happen. And what I've seen over time is they phone up, you say, oh, we'll have to get the will out of the strong room, or nowadays it's kept off site, we'll phone you back in 2 days. In that time, there is a lot of opportunity for what I would say drop off, because you would have a situation where the family maybe go and see the funeral director, who may have a link in with someone else, say, oh, go and speak with ex-solicitors, or go and speak with someone else. Or they speak to other family members who say, oh, John down the road is an excellent private client lawyer, he'll be able to help you. Whereas, and then you phone about 2 days later, and it's like, oh, we found the will. Oh, great, we found another solicitor. And we're going to use them. Whereas if the will's scanned on, you very quickly you're able to start the relationship off with the clients on a good basis, because you're able to bring the will up and say, oh, you can ensure you're speaking to the right person. If it's a daughter who phones up and she's not an executor, you could say something along the lines of, oh, have you got a sister? Can she phone me? Or something like that. You're able to arrange an appointment, and you're able to provide some guidance regarding the funeral. And it shows you are efficient, because you're able to answer that question at the first point of call. And that will then, you're already heading off another solicitor because you're making the appointment. It doesn't have to be straight away, it can be after the funeral, but you're starting the relationship off on the right foot. And I think that will increase the amount of probates that you are able to retain in practice. You're always going to have wills that will go to another firm, because it's the nature of the beast. People will say, oh, I use Jones & Co down the road for my own personal work, and I'm going to use them. But I found that it's a very cost-effective way. It's a great thing for work experience people to do, maybe. Come in to scan the wills, or you can get companies to come in. I know at Slater & Gordon, when I was previously there, we got a company to come in to scan all the wills in. Obviously, you do have to train them that they don't always scan it then shred the original. You have to give them instructions in words of one syllable. You do not do anything to the will apart from scan it. You treat it like a newborn baby, for example. But that will be a quick win. It's a cheap win, and I think once you start doing it ongoing, it's a very simple thing, because you get the will, you sign it. Get it, the will signed, you get it scanned in. And also, something that Presky and I were talking about before, if there's any errors when you've signed the will, say, for example, if one witness hasn't signed it, it comes out at that stage, because and the person's still alive. So you're able to go, oh, crikey, this hasn't been done right, and you can fix it. rather than just putting it in an envelope, sticking it in the strong room and forgetting about it, only to find out the will hasn't been executed properly.
Can I just add something at that point, which is a bit of a left-hand turn at the traffic lights? But if you're instructing somebody to scan, it's always worth saying to them, check whether it's double-sided or single-sided. And on the back of that, I was listening actually to Ian Bond, who's on the Probate Users Group, and he was saying that if you're making an online application for a grant, one of the most important things to do is there's a little box at the end of your application which says, do you want to say anything about, your application? Optional. He said most people don't put anything in there, but actually it's a really good idea to put in there, this will is double-sided. When it's scanned, please make sure that you scan both sides, because the scanning's done in Harlow and the people who are actually processing the application are working from the scanned documents based in Birmingham. And he said that apparently there's been a whole series of stopped applications with Birmingham saying, oh, your will's missing various pages. It's missing pages 2, 4, 6 and 8. And of course, then you're in the stopped bracket and it takes forever to get yourself out of it. And it's not your fault. Infuriating. So I just throw that in.
No, that's crazy.
Yeah, but it's a really useful tip, isn't it?
It is. I hadn't heard of that, so that's something I'm definitely going to be telling the team after this.
Yeah. Okay, Amanda, moving on.
There we go. Learn something new. So coming to you now, Lesley. If I have an estate where everything is going to a surviving spouse or charity, so it is exempt, do I need to check for lifetime gifts?
Well, the problem is, isn't it, that your deceased might have made some lifetime gifts in the 7 years before they die, in which case those gifts are going to become chargeable because they've died within 7 years. If those gifts exceed the nil rate band, there will be some inheritance tax to pay on those gifts. Now, initially, the person who is liable for the tax on those gifts is the lifetime transferee. But if the lifetime transferee doesn't pay the tax within 12 months, then the personal representatives become liable for the tax. So you've got two issues. One issue is if you're the personal representative, you have to fill in your estate accounts and you have your IHT forms, and you have to say whether or not there have been any lifetime gifts. So you need to find out whether or not there have. But then also, if you find that there have, and there is IHT to pay, you don't want to be distributing all of your assets to the spouse or the charity before you know that the IHT on the lifetime gifts has been paid. So yes, you do need to find out whether or not there have been any lifetime gifts.
Great, thank you. So I've got a question for James here, but I think we may have answered it further earlier on in the discussion. And do we have to prepare interim estates accounts?
Oh.
We did.
we
did, and the answer is still the same. It depends. It's a very good question, I'm sure. Yes, it depends. I would say a straightforward estate, less than the nil rate band, under a year, no. Anything longer than that, yes. But it really does depend, and at times as well, perhaps ask the clients. Do they want to pay for interim estate accounts? As with all these things, if a client wants you to do something, and they're willing to pay for it, you can do it. But I think you need to say to them, I wouldn't advise it. Or at times you can maybe placate the client with just a schedule of the estate, which I would advise people when you send out your inheritance tax return. I would always advise you send them a schedule of the estate at the date of death. If it's easy enough, just run one of those off for them.
I think agreeing regularity of communication and exactly what, agreeing with the clients, how often you're going to communicate with them and about what is really important. And I'd go back to my charities as residuary beneficiaries and say it's particularly important with them. So I always remember reading an article by the previous, probably previous but one, head of the Institute of Legacy Management. And he said, oh, well, we charities don't mind paying a bit more in fees so long as we get good service. And I thought, yes, well, I think I just want to agree, exactly what they were willing to pay and what level of service they wanted.
That's great, thank you, guys. So I've got one for Lesley now on reservation of benefit.
Oh, good.
Is it the case that once 7 years has lapsed from the date of the gift, we can stop worrying about it?
No, no, it's not. Reservation of benefit can come back to bite you at any time, because if I have given something away to my daughter, let's take a valuable picture, which frankly I don't own, but let's imagine I did. So I have this valuable picture and I give it to my daughter and she takes it away and it's in her house and there's no question of reservation of benefit or anything else. And then for some reason or other, she brings it back and I put it on my wall. And this could be 10 years after the initial gift, but it comes back and hangs on my wall. And that starts the whole thing off again because I now have a reservation of benefit again, or I have a reservation of benefit in that painting. Because the second limb of the reservation of benefit rules says that if the donor hasn't been excluded from virtually all benefit in the 7 years before death, there is a reservation of benefit. So take another example. I give my daughter a house and I'm living elsewhere, no issues. I move in with her in the 7 years before death. Now, there is an exception for unforeseen ill health or change of circumstances. But if I've just, for example, moved back in with her because I've sold one property and I'm going to buy another one, if my shared occupation with her is for anything more than de minimis, more than a few days, a few weeks, I've again got a reservation of benefit. And if I die within 7 years, that reservation of benefit's going to be relevant. So you can never really forget about the reservation of benefit rules. Once you've made a gift, you've got to make sure that you don't suddenly start enjoying a benefit from the property that you've given away.
It's interesting you made the point about the paintings. I had a client about 10 years ago where he had some very, very expensive paintings and we're speaking to each other. Oh, I've given them away to the children. They're no longer mine. So, oh, what are they then? Well, one's in the dining room, one's in the kitchen, one's in the lounge because the kids, because the kids can't afford the insurance or the security.
Yes.
And we ended up having to get, if memory serves me correct, we ended up getting a quote from British Gallery to see how much it would be for her to rent.
I was just about to say,
the painting.
That's what you do in that situation. You pay full consideration for the rental.
Oh, we got the rental figures, and it was eye-watering. And she's like, "I haven't given her away now." Then no, she wasn't. She was Yorkshire, so she wasn't going to pay. She wasn't going to pay the rent. Put it that way, and I can say that as a Yorkshireman. But it was just interesting. Oh, they're not mine. They're just here. She in her mind, she had given them away.
But that's perfectly understandable, isn't it? And yeah. I've heard versions of that before, which is why I was using the painting initially as the example. But yeah. And, the children are probably living in rented accommodation and it's actually not safe to have a valuable painting hanging on the wall.
Yeah, so. I think some of them will be worth more than where they were living.
Yeah.
Yeah, living in a 50 grand flat, but with a 100 grand picture on the wall. Yeah, it's.
I've just had a question come through, which may relate to what we're just talking about. It's about specific gift and nil rate band legacies. When to use and how to draft, so there is no confusion whether it is a sole NRB or TNRB, and would it include RNRB? I hope you understand all those. I have no idea.
I understand it. I'll have a go first, and then James might add something. So what we're talking about here, I assume, is a gift of an amount which is equal to my available nil rate band at the date of death. So it's effectively a pecuniary legacy. Sometimes you leave it to the children, absolutely. Sometimes you'll leave that amount to a discretionary trust, but it's a gift of an amount. You want to be as clear as you possibly can. And I would festoon it with explanation, because, you know, the case, we have a litter of cases on uncertainty about what exactly the wording of a will meant. So if somebody wants to give away the maximum that they can give without a payment of inheritance tax, I would say that. And I would say, I would add, and this is belt and braces, taking into account any transferable nil rate bands. And then I'd probably go even further, because the transferable nil rate band has to be claimed. And so I would probably put in a separate clause saying, if this was what I wanted, and I direct my executors to claim any transferable nil rate band that's available at the date of my death. If that wasn't what you wanted, if what you wanted was simply to give away an amount which is equal to the nil rate band at the date of my death, you can say that. You can say an amount which is equal to, and it's a figure in the table of rates in the schedule to the Inheritance Tax Act, which sets out what the single nil rate band is at the date of death. But again, I'd go belt and braces, and I'd say, if this is what the person wants, not including the benefit of any transferable nil rate band. So I would spell it out. Now, I think in that question, there was a bit about, and what about the residence nil rate band? Now, if you're giving a pecuniary legacy, residence nil rate band is completely irrelevant, because it only applies where a residence or an interest in a residence is being inherited. So if you've got something like, I give an amount equal to the largest amount I can give without payment of inheritance tax, you completely forget about residence nil rate band. But if somebody dies and they no longer have a residence, then there's a very good chance that their estate will be entitled to a downsizing allowance, which is an additional nil rate, effectively nil rate bands that you can get, so long as sufficient assets are being left to your lineal descendants. So you may want to put an extra bit into your pecuniary legacy gift. So you may want to say, not just including the benefit of any transferable nil rate band, you might also want to add, and including the benefit of any downsizing allowance that's available on the date of my death, because that will increase the amount that can go to your pecuniary legatees. But it's a question of working out how generous your testator wants to be to the legatees. Are they wanting to give as much as possible? And then just spelling out exactly what you want to be taken into account. And James is looking as if he wants to say something, but I'm just, well, I've got one other thing I want to say.
No.
But go on, say your bit.
I was going to say, I agree. I think it's clarity. You know, you just got to make sure it's clear as day. That's my only comment. Okay.
Well, there is another case that I'd just like to mention, which is a recent case, which I thought was almost certainly harsh and almost certainly not what the testator wanted. And it's an example of not making things clear to the testator, I think, from reading the report. This was a case where old friend was appointed as executor. And the first gift was a gift of the most that I can give without payment of inheritance tax to my old friend, the executor. And this was followed by 2 specific gifts, which were free of tax. And then I think the residue was going to various charities. And the problem was that the 2 specific gifts were a gift of a flat and a gift of some investments, and they more than exceeded the nil rate band. So, the amount that the old friend and executor was going to get was nothing. But it looked pretty clear that it was likely to be nothing from the very beginning, because if you've got a flat and quite a large shareholding, the chances that that's going to exceed the nil rate band are quite high. Now, we can't tell from the report, but had there been some correspondence between the person drafting the will and the testator saying something like, you do understand, don't you, that if these gifts come to more than 325,000, this gift to your executor can't take effect, I don't think that the litigation would have started, because there would have been a reply which said, yeah, that's fine. That's exactly what I want. I just want to make sure that my nil rate band's used up, and then I want everything else to go to charity. So it did occur to me that these gifts, if you've got other chargeable gifts in the will, you do need to spell out to the testator exactly how they're going to work.
Well, that's great.
Okay.
Thank you very much. And I'm going to give you rest for a moment, Lesley. We're coming over to James. Bit of quite a turn of question now. So, if we invest in a case management system, won't it affect our team's knowledge?
It depends on your team. No, I think that's a really good question, because it was something that I've gone through over the years when considering case management systems. And there are different types. There are some that are very light touch and still require your lawyers to use their brain in the administration of the estates, whereas some of them really do take you by the nose through the whole process. Personally speaking, I don't like them, because your lawyers need to know what they're doing and why they are doing it. They can't have I would never want a situation like, why are we doing this? Oh, it's because the computer told me to do it. So yes, there is a risk, but I think through internal best practice and regular training of the lawyers, that can be mitigated. I would say that if you are considering a case management system, to get the software providers to come in and look at it, and look at the ones and find the one you feel most comfortable with. It's an old role of mine. We actually designed our own. So we bought a skeleton case management system from a company called SOS. And using our own in-house IT team, we then built it to work for our team. And I appreciate most firms may not have the look of having an in-house IT team who can do that. But it was fantastic, because I was able to sit there and say, I want it to do this, I want it to do that. And actually, we got it working for us, and it really did drive efficiencies. And it helped people. The first thing we had to get over with the lawyers was, I'm just turning into a data entry clerk. And we worked it out that over the course of an estate, you'd probably spend an hour entering data. But then when you saw it prepare estate accounts that balanced, and when you saw it preparing the inheritance tax returns and the saving in time there, it was quite something to watch. So I think you need to judge it. If you have a team of relatively junior lawyers, potentially the more advanced case management software where it talks you through it would help from a risk management point of view, because it can cut down the chance of any errors. But personally, I don't like it, because we're lawyers. We are paid to advise our clients, and I think if you just might as well get machines doing it if you're going down that route. So it's a choice for each firm. I would suggest look at all case management software and then choose the one that you think that fits in with your particular team.
That's great, thank you. So on for Lesley now. Who has to be a party to a variation? Does the new beneficiary and do the PRs?
Strictly speaking, with one exception, the only person who has to be a party is the person who is making the variation. That's where you start from. There's one situation where personal representatives have to be a party, and that's where more inheritance tax is payable as a result of the variation. It's comparatively rare that you would have a variation that increased IHT, although you do sometimes. And the reason for requiring the personal representatives to join in is that they will be liable for that extra IHT. And the statutory provision says that they can't refuse to join in once they've been put in funds to meet that extra liability. So the requirement that the PRs join in is just to make sure that they are not left out of pocket. It's usual to get the new beneficiary to be a party, but it isn't necessary. But it's just, quite a useful thing to do, particularly because you're usually using a deed. And so getting everybody to be a party to the deed can be helpful if there's any problem along the line. One other thing I just ought to mention is if you're doing a variation to give more of the estate to charity, this is the one situation where the charities don't necessarily have to be a party to the variation, but what you do have to do is you do have to have some evidence that the charity knows about the variation. And this apparently was introduced. It's an amendment to the Inheritance Tax Act. And it was apparently introduced because the charities reckoned that there was a bit of a dodgy business going on with people doing post-death variations, showing them to the revenue, getting the charity exemption, and then just quietly putting the variation away. Because, of course, while a will is a public document, so it was possible for charities to monitor wills as they were proved. A variation isn't a public document, and so there was actually no way that the individual charities could know that this variation had happened. And I do remember lecturing with somebody just after this change had come in, and he was saying, when he heard this, he went, "Oh, nobody would do that." And then almost immediately afterwards, what should come in but a case where exactly that had happened. It had been discovered later down the line, and the whiter than white people were going, "Well, what should we do about this? It's terrible." So that's the only case where they don't have to be a party, but you do have to get confirmation that they know.
I've got one here that I think follows on from that one, Lesley. So if varying on behalf of a dead beneficiary, who signs the variation?
I should give a plug here for the IHE manual, which is actually now... People still tend to shudder a bit when I mention the manuals, because when they were first made public, they were fairly baffling and quite poor, but they have been dramatically improved. And there's some very, very good stuff in the variations section of the manual. And it deals specifically with the fact, first of all, that you can do a variation on behalf of a dead beneficiary, which isn't immediately obvious. And then it talks about who should sign the variation. And it says that the personal representatives of the dead beneficiary should sign, but they should also get the consent of the beneficiaries of the dead beneficiary, if you see what I mean, in writing. So if it was a gift from uncle to nephew in the will, and nephew is dead, and nephew has left his estate to his daughter, then nephew's executors should sign the post-death variation on behalf of nephew, but they must get the written consent of the daughter. And that can either be in the variation by getting her to be a party, or it can be a separate written consent. But it's set out in a really helpful way in the manual.
That's great, thank you. So I've got one here for James. How can we keep estates accounts simple?
Only
Good
deal with
luck on
simple
that one,
estates.
James.
I know. How do we keep it simple? Well, I think you need to look at it from the client's point of view first, not from a lawyer, an unnamed lawyer in Cardiff's point of view about making this complex so they don't get any questions about it. So I think look at it from a client's point of view. Whilst there's no structure set out how the estate account should look, I'm a great fan of the way that STEP set their accounts out. And I remember when I did the STEP diploma way back when, for that exam, I just said from this day forward, I will always follow the way they do it, because it'll help me pass my exam. And it did. And I've used it ever since. So I think it's adopting a clear order that shows the story of the estate. So from date of death through any variance in capital, income, and then to the distribution. I personally find balance sheets confusing, so I dispense with the service of a balance sheet. And I always think if I find it confusing, a lay client may find it confusing. I do extol the virtues of using appendices to the accounts, so as not to just have one long page of, say, expenses. Use them to separate out, use some white space, and really just think of how can we make this as clear as possible, because to me, our duty as a lawyer is to make complex simple for clients whilst containing all the relevant information. So I think it's a case of looking at your own estate accounts and going, do these work or not? A chap I used to work with always used to use his father as his sounding board. And if ever he had an idea, he wasn't a qualified lawyer, he's retired. He used to take it back to his dad and say, what do you think about that, Dad? It's like the man on the Clapham omnibus. And you'd take it to someone and say, do you think these are clear? What's your opinion? And if they look okay, I can understand them, then that's a good way of doing it. At one firm I was at, not the lady who did the £6,000 estate accounts, we had another one, and her estate accounts, they made sense to man nor beast. But it's the way that she was trained 20 years previously, and the guy who trained her, and that was the way he had been trained. And I think it's the opportunity to take a step back and think, do these work in 2021? Are they clear? Do they make sense? So lots of white space, use appendices, and look at it rather than from a technical point of view, but from a client's point of view.
Yeah,
I appreciate it's a bit of a verbose answer for what could be a fairly simple question, but if it's a reason to do the STEP diploma, I think it's something to look at, because I found it very helpful in my career.
Great, thank you. Got one for Lesley now. So I believe that all trusts now have to be registered with details of settler and beneficiaries. If the settlement is created by variation, who is the settler?
Oh, that's a very good question. And now I know the answer to this, and I'm trying to remember why I know the answer to this and where I read it. But at the moment, senior moment, I can't remember where I read it. But the reason it resonated with me was, if you remember, I said that a post-death variation is read back and treated as the deceased's for the purposes of capital gains tax and inheritance tax. But that's it. So if you're actually creating a post-death variation, if you're actually creating a settlement by means of a post-death variation, the person doing the varying is the settlor for the purposes of the trust's register. So that's only for the purposes of the Trusts Register. It's not for the purposes of IHT. But I think it must have been, oh, I know where it must have been. It must have been in the new manual that the Revenue has done for the purposes of the Trusts Register. So it's the person doing the variation who is the set law. And if you have a flat management company, the beneficiaries are the flats, apparently. Somebody told me that, but may or may not be true.
I have another one here for you, Lesley. An appointment from a relevant property trust is read back to the date for IHT purposes. What about CGT? Is there a similar provision?
No, there isn't. The Section 144 of the Inheritance Tax Act, by definition, applies only for IHT. There is no equivalent for capital gains tax purposes. So if trustees do an appointment out of a trust within 2 years of death, they are making a deemed disposal. That's your normal rule. However, and this is dealt with at some length in the capital gains tax manual, the Revenue does accept that if the trustees appoint out their right to receive the property from the personal representatives before the personal representatives have transferred any assets to them, the trust never comes into existence. Somebody said to me once, it's sort of strangled at birth. So if you are worrying about capital gains tax, the thing to do is, before any assets are actually transferred to the trustees, if the trustees know they want to get rid of the trust and give everything typically to the surviving spouse, they should get on with it and do it before any assets are transferred. And then the person who's taking the assets takes them from the personal representatives as legatee, and the trust never comes into existence, it just drops out. But there's nothing in the capital gains tax legislation to say that, but it is in the capital gains tax manual that that's how the Revenue treat it.
That's great, thank you. So I've got one for coming over to James now. So you mentioned reviewing our precedents. How do we start?
How do we start? That's a good question. So yes, this was part of the Practical Probate webinar. So having an effective precedent bank is one of the most ways to make you more effective and potentially more profitable, because you cannot be punished for being efficient. And when I say that, by having the precedents in order, that you can simply dictate, send precedent letter 7 to XYZ, these are the estate numbers. That can be 1 unit of time recorded for 7 letters going out. So what I suggest you do is print off all the precedents you've got. I suggest you and the team lock yourself in the boardroom with a pot of coffee and maybe some pan of raisins, or some croissants, depending on the budget. And then you go through each letter one by one. And you look at, are we duplicating letters? Is there a way we can be more efficient? When I was at Slater & Gordon, we did this. We'd acquired 2 more firms with private client departments, and we spent 2 days, myself and the other 2 heads, locked in a room, and we went through all our precedents and created, what was good from that precedent, what was good from this precedent, and we created. Well, I was proud of it when we finished. We had a fantastic set of precedents that struck the right balance and got all the information. So, for example, one of the firms had 4 letters to NS&I. And I was like, well, why have I got 4 when 1 would do? Just use some square brackets and take them out. And you can just, when you dictate in the letter, tell the typist, it's regarding premium savings bonds. And just by doing that, taking out anything you don't need, seeing which letters can be used for similar but not the same organisations, you will be able to get a decent precedent bank, maybe with 50 letters that will cover pre-grant, grant application and post-grant. And then what you do, you just keep them up to date as you go along. If anything changes. So, for example, with sending any postal applications off. You know, before the pandemic, sent everything down to Harlow, and then since February this year, it was, oh, Harlow are no longer accepting postal applications from professionals, send it to Newcastle. But we're not going to update the website to tell you that. So I think just keep it updated, keep on top of it, and it's a bit like a paper cut. It hurts initially, but then it heals very quickly. So I think just bite the bullet and do it, and you will start reaping the rewards.
That's great, thank you. So I think this might be our last question, but we'll see how we get on. For Lesley, with sharing arrangements and reservations of benefit rules, is it okay if donor and donee share expenses equally?
This is looking at the exception, one of the statutory exceptions to reservation of benefit, which says that there is no reservation of benefit where the donor gives a share in a residence to a donee, provided the donor does not derive any more than an insignificant benefit from the gift. So your typical scenario is mum with unmarried child living with her, worried about inheritance tax on her death, so she gives a share of the property to the adult child and they carry on living there. What you've got to avoid is mum getting any benefit from the arrangement. And so if the adult child said, I will pay all of the expenses, then mum would be getting a benefit. So you'd think if they were sharing the expenses equally, they ought to be all right. And they probably would be. But the revenue is always very suspicious about these arrangements. And what you sometimes get is adult child who works abroad a lot of the time and uses mum's house as their base when they come back. Now, immediately the revenue is going to be unhappy, you know, when you claim that there was no reservation of benefit, because adult child isn't living in the property full time. But, you know, you can have more than one residence and you should be okay establishing that, yes, there was shared occupation, so long as you have some evidence that the adult child came back, you know, every time they went working abroad, they had their own key, they kept their possessions in the house. The revenue tends to ask things like, where were they registered with a GP? You know, this is a bit old fashioned, but where was their library card? You know, those kinds of things. So assuming that you can establish that, yes, there was shared occupation, but if mum's in the house for effectively 9 months of the year and the maximum that the adult child is spending is 3 months of the year, then sharing the expenses 50-50 immediately raises the issue, was mum getting a benefit? So you can't necessarily assume that a 50-50 split will make you safe. But if you've got a 75-25 split with mum paying the with mum paying the 25 and the child paying the 75, you're definitely in trouble. Other way round, and it's fine. So mum can pay a bigger share, but she mustn't pay a smaller share.
That's great, thank you. So unfortunately, that is all we have time for today. Thank you for attending Law 2021 Online's Wills and Probate Shape the Debate. Thank you to our expert speakers, Professor Lesley King and James Beresford. Don't forget to join the Solicitors Group's Law 2021 online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within the next few days. There is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. And there is still time to buy the complete event, including a recording of this live session if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The exhibition is open for anyone to visit, and if you've booked the entire event, you can claim your free 1-hour CPD webinar from our webinar programme, worth £35 plus VAT. You can also visit our exhibitor profile for more information on our sponsors for today. Finally, feedback forms for the event will be sent out when the event closes. By completing this, you will receive your CPD certificate. So all that's left for me to do is say thank you again. We hope you have a great day, and thank you to Lesley and James.
Thank you, Amanda.
Cheers.
Bye.